Mirror, mirror in my hand, who is the cutest man in this world? It's me, Danny.
No. It's Adilah. Hi, I'm Xin Yi. Hi, I'm Zhi Yi. I'm Yng Yiin. And I'm Xin Yi.
Please
Enjoy our video!
Land law is a subject steeped in history. It has its origin in the feudal reforms imposed on England by William the Conqueror after 1066. And many of the most fundamental concepts and principles of land law spring from the economics and social changes that began then. According to Gray and Gray, the objective of land registration is so as to ensure that any prospective purchaser of registered land should always be able to verify, by simple examination of the register, the exact nature of all interests existing in or over the land which is proposed to buy. Entailing this, a number of benefits can be derived from the registration of land. Firstly, this can reduce the expense and effort of purchasing land by eliminating the lengthy and formalistic process of investigating the root of title in the land. If title is registered, the owners of the land will be easily discoverable. Secondly, registration of land can reduce the dangers of purchasing land with unsafe or unclear title. A purchaser can rely on the registration of title to ensure that the title has been approved by the land registry and whose validity is guaranteed. Thirdly, it provides a clear system where a third party's interest can safely be ascertained, thereby ensuring that the price paid by the purchaser reflects its true economic and social value, as well as enabling the purchaser to buy land completely free from any types of interest over the land, which may consequently take effect in the money paid to the seller. This is what is known as the overreaching concept. Last but certainly not the least, registered land also provides a clear mechanism whereby certain third parties' right in land can be protected and so survive a sale of that land to a new owner. For this reason, the unregistered land doctrine of Nordics plays no part in the system of registered land. A sound system of land registration is underpinned by three major principles, namely the insurance principle, the curtain principles, and the mirror principle. The insurance principles refer to the guarantee secured by the state that any loss incurred by registered land resulting from reliance on the conclusiveness of the land registry by a land purchaser will be compensated through a statutory indemnity system. The curtain principle, on the other hand, is the concept that land registration may allow certain equitable interests attached to the land hidden from a purchaser view. This curtain, however, does not affect the validity of any transaction on the registered land so long as the details of the registration reflects the validity of the title. Finally, there's the mirror principle. In this video, we will be focusing on the mirror principle. In a general point of view, the mirror principle encapsulates the idea that the register should reflect the totality of rights and interests attached to the land. Thus, the inspection of the register should reveal the identity of the owner, the nature of his ownership, any limitation on his ownership, and any rights enjoyed by other persons over the land that are adverse to the owner. The point is simply that if the register reflects the full character of the land, any purchaser or any third party can rest assured that they are fully protected. The purchaser knows what he is buying, and the person with an interest in the land knows that it will be protected. However, the mirror principle does not operate fully in the system of registered land. Even under the LRA 2002 Track Mirror, this is mainly due to the existence of a category of rights that affect the land and which bind any transferee of it, including a purchaser, without ever being registered. Always remember that registrable interest, if registered, binds whole world. If not registered, binds no one, except non-purchaser.
While it can be said that some people would own the land, the reality is the land belongs to the crown. Therein lies the question of what then would safeguard the ownership of land by any party or any corporeal and incorporeal rights of a third party. To answer this question, it is first pertinent to look at the type of rights that people can be registered with in the acquiring of their own title to the right. Title in this respect is what works the same function as an ownership of land. So within this section of the video, by strict application to the provisions of the Land Registration Act 2002, we shall look at the registrable estates in protecting any title which it may encompass. as what are regarded as estates, freehold estates and leasehold estates granted for more than 7 years will acquire title should they have performed the first-time registration to the registrar as a proprietor of one of the two estates. There are, however, instances where registration for the title could be made by compulsion. These instances include when the possession of the estate is via transfer as a gift, as a compliance to a court order, or upon death. So, this compulsory registration can also happen where the grant of lease is for more than 7 years and where a reversionary lease is granted. This is namely a grant to allow a lease to take effect after the end of 3 months period. Should any situation fall within these instances, or should any person with the possession wish to voluntarily register for their estate, the registration at this point has still only gone through the first-time registration process only. Why though would this first-time registration process be important in the protecting of legal rights of possible title owners? So, as laid down under Section 7 of the Land Registrations Act 2002, in situations where the reason for registration is a freehold or a leasehold with more than 7 years unexpired, non-registration for the first time would render the legal estate to be reverted back to the transferor, who will then hold the estate on trust. And also, where the title to be registered is of a first-time legal mortgage, the effect of non-registration is to treat what has happened as a contract for valuable consideration to grant that particular interest. To put it in simpler terms, late registration or non-registration is no doubt but for the cost of the person whom it is within his responsibility that registration should be made. It goes back to the reason why first-time registration is made, that is to allow the process by the registrars and cautioners to regard as to the validity of the title registration. This is because should there have been any possession of the estate undermining the rights of any third parties, Section 71 of the Land Registrations Act 2000 makes it a compulsion to take the matter to an adjudicator. The next step after a first-time registration has been successfully done and that the title has been registered, there has to be a registration in becoming the proprietor of the estate, as provided by Section 27 of the Land Registrations Act 2002. For a subsequent transfer of a registered estate to take place, it has to go through another registration process so that the transfer will operate at law. The result of this is that the new registered proprietor will take the estate subject to only the interest entered on the register and also interests which override the register, which will be discussed about further on by my fellow teammates. When title is registered at land registry, following the procedures as prior stated, it would now be vital to show the validity of the claim to be registered as proprietor. The register must accurately reflect the state of the ownership, especially since it will compensate anyone who suffers a loss due to errors present in the register. The classes of titles are laid down within Section 9 and 10 of the Land Registrations Act 2002, namely classes such as absolute title, to entitle that someone has a better right than anybody else to that estate, a possessory title where registration is based upon possession of the land as opposed to any mere transfer of an unregistered legal estate, a qualified title where there is an effect with the title like due to a loss of deed, and a good leasehold title where the registrar is happy with the title granted to the tenant under the lease but not as the title of the lessor. To conclude, rights to estates are considered by law and that via registrations of estates, protections to rights are safeguarded.
The continued recognition of registered charges by LRA 02 evidences the Act's commitment to uphold the mirror principle. Registered charges are derived from the power of the registered proprietor to mortgage the land in order to release its capital value as mentioned in Section 23 of LRA 02. Pursuant to Section 12 and Section 30, it is mandatory for charge by deed to be entered on the register against the affected title if it is to retain its legal interest with the priority that it entails. the charge certificate, which is the mortgagee evidence of a valid mortgage as per LRA 1925, has been abolished by the LRA 02. The Act has deemed it to be irrelevant since the register itself is open to inspection. The creation of a registered charge over a registered estate is likely to be an early subject for e-conveyancing because most institutional lenders are geared up for the paperless mortgage transactions. They had in fact already operated an electronic system which HM Land Registry for the discharge of mortgages, i.e. removal from the register after they are paid off. It was clearly illustrated in the case of Barclays Bank and Zarul Babli that a failure to register a mortgage equated to a loss in priority when compared to a subsequently created legal list of the land. However, in this permanent building society and family, the mortgagee was more fortunate in that although it had failed to register its mortgage, the later list was itself equitable. As a result, the rule that the first in time prevails became operative and the prior equitable mortgages prevail. A similar result to family is found in the case of compact. On the other hand, the retention of retrievable interest, which are also known as minor interest, is another evidence substantiating the fact of LRA 202 commitment to upholding the mirror principle. Nevertheless, under the LRA 02, there is no specific category known as minor interest, but the Act has gone on to embrace the rationale behind LRA 1925 to recognize that third-party property interests should be entered on the register against the estate they burden. A failure to do so would mean that the property right loses its priority against the registered proprietor unless the right fall within Schedule 1 or Schedule 3 of LRA 02 and qualify as an overriding interest. Accordingly, these rights are known as interests protectable by registration, which include categories of covenants, option to purchase, and many easements. Under the old law, there were many different methods by which a third-party interest could be protected, unlike under LRA 02, where substantive protection of interest can only be achieved by entry of notice. It may be unilateral or agreed, and the registered proprietor may be controlled in his ability to deal with the land by means of restriction. Recognition of such proprietary right is indeed fundamental to the land registration system based on LRA 02, and it enables owners, purchasers, and third parties to know early how to protect their rights and what will happen to those rights if the land over which they exist should be sold, mortgage, or transfer. In addition, the abandonment of the doctrine of notice in registered land is also said to bring certainty and stability for persons who have right in land that is owned by someone else. It's clear that the intention of registration and protection of minor rights in the LRA 02 operates according to two rules, namely, if the minor interests are registered as a charge in the charge register, they acquire protected priority. In other words, it binds any subsequent disposee of the registered estate, whether or not the proprietor inspect the register pursuant to section 29 sub 2 sub A sub 1 LRA 02. However, if they are not registered as a charge, protectable interests are subsequent in priority to the interest which passes under any registered disposition made for valuable consideration. They will only remain enforceable against a disponee otherwise than for value, such as a donee or a trustee in bankruptcy as per section 28 sub 1 LRA 02. Besides, following section 29 sub 2 sub A sub 2, unprotected minor interest will be ineffective against the registered proprietor unless the entitlement in question also qualify for protected status as unregistered interest which statutorily overrides registered disposition of the estate. There is, according to the Court of Appeal, no general principle which render it unconscionable for a purchaser of land to rely on a one-off registration of a claim against registered land, even though he took with express notice of it. Then a decision to the contrary would defeat the purpose of legislature in introducing the system of registration in Lloyd and Dugdale.
Plain from the foregoing discussion above, the middle principle of land registration is undoubtedly one of the three fundamental principles where the register of title is a mirror that reflects accurately and completely the current facts pertaining to a title. While this may be true, overriding interest in registered land have been the center of debate for many years. In fact, they have been around since the enforcement of the LPA 1925, and it appears to distort the middle principle. They are quite literally unregistered interests which override the registered title and which thus permit the right holder to exercise the right against the land irrespective of who the registered proprietor is, and even though that right is not registered. Examples of overriding interests include certain rights of occupation, easement, as well as leases for a term of less than 7 years. Consequently, overriding interest under the LPA 1925 has often been described as the crack in the middle of title, given that the interests were not reflected on either the registered title or the land registrar. The 1925 Act was subsequently replaced with the LRA 02. As a matter of fact, the full list of disclosable overriding interests can be found in Schedule 1 and Schedule 3 of the LRA 02. In accordance to this Act, overriding interest may take effect against a first registered proprietor or against a person who becomes the registered proprietor on the transfer of a title that is already registered. Interests which override at first registration are defined in Schedule 1 of the 02 Act, and the interests which override following the transfer of land that is already registered are defined in Schedule 3. In relation to LRA 02, paragraph 1 of Schedule 3 provides that legal leases which are less than 7 years will override a registered disposition and are automatically binding on the landlord's estate. This includes parole leases as illustrated in Section 54 Sub 2 of the LPA 1935, which is automatically legal without a need for a deed or being registered, as well as short lease as provided in Section 52, where only a deed is required. In addition, Section 157 of the Localism Act 2011 also added paragraph 1A to Schedule 3, and this provides that a relevant social housing tenancy shall override irrespective of its length. These are specialized leases granted by private providers and were encompassed in the list of the overriding interest, as it is significant that they always have the priority even if the superior title changes hand. In a nutshell, a legal lease under 7 years is allowed to achieve legal status even if unregistered, provided that there is a lease if the lease is between 3 to 5 years or already if the lease is under 3 years. On another note, paragraph 3 of Schedule 3 replaced, in relation to registered disposition, Section 70 Sub 1 Sub A of the LPA 1925. Pertaining to LPA 1925, on first registration, any legal easement or profit appended is an overriding interest. Nevertheless, as a result of the qualification found in Schedule 3, fewer easement and profits will override a registered disposition that will at first registration due to the exception provided. In essence, paragraph 3 of Schedule 3 makes it clear that, firstly, no equitable easement of profit will override, and secondly, only certain type of legal easement or profit appended may override. Legal easement and profit expressly granted or reserved out of a registered title are excluded from the category of overriding interest, as their creation amounts to a registrable disposition under Section 33 of the LRA 02. In other words, they are required to be registered in order to operate as a legal interest. This means that only legal easement and profit capable of being overriding are either those expressly granted out of an estate which is not registered, for instance, a lease of 7 years or less, or more commonly, those that are impliedly granted. While this may be true, there have been some exceptions where an unregistered legal easement or profit will only override a registered disposition if one of the 4 requirements is satisfied. That is, an easement registered under the Commerce Registration Act 1965, an implied legal interest within the actual knowledge of the transferee, or if the legal interest is obvious on a reasonably careful inspection of the burdened land, or the person entitled to the benefit of the legal interest proves that it has been exercised in a period of 1 year ending with a day of disposition. As a concluding remark, an unregistered legal easement will bind transferee only if the transferee knows about its existence if the acquisition was objectively obvious on the inspection of the land, or if the easement has been exercised within the last year, or has been registered under the Commerce Registration Act 1965.
Continuing the aforementioned points, another visible and striking crack on the mirror principle in registered land is the overriding interest created by the actual occupation. The very fact that an individual has a right which cannot be discovered by inspecting the land register can create problems for a prudent purchaser who has been misinformed by the vendor as to the presence of other persons on the property. The purchaser is faced with the problem of finding out as much as he or she can before purchasing the land, and this burden definitely distorts the absolute certainty which is the ideal of the registered systems. According to Sir John Stuart Wallace, the fact concerning actual occupation is to the extent that absolute title becomes something of a misnomer. Nevertheless, one must on the other hand recognize that overriding interests are a double-edged sword and do provide pivotal protection to individuals who are often in a vulnerable position. Lord Russell in Counts and Counts had pronounced that it is the principle of law that a person in occupation is protected in his right by that occupation, unless of course the rights are such that they require registration if they are to be protected. Hence, a purchaser must pay heed to anyone in occupation if he is to be sure of getting a good title. Lord Denning in Strand Securities and Caswell had also endorsed the same principle by stating that an occupier may simply stay there and do nothing as nobody can buy the land over his head and take away his rights. A balance was sought by the Land Registration Acts to reflect the needs of the parties in such circumstances, and the legislation will continue to protect those rights which, if not accorded the status of an overriding interest, could lead to the loss of a home or the perpetration of fraud. By virtue of Schedule 3, Paragraph 2 of Land Registration Act 2002, an interest belonging at the time of disposition to a person in actual occupation shall be an overriding interest. In dissecting this proviso, the first word to take note of shall be interest. The interest could be a legal as well as an equitable one, which arises from an express trust, implied trust, or statutory trust, regardless of whether it is registrable or not. Although beneficial interests under a trust were not intended to be overriding interests under the original Section 70, Sub 1, Sub G of the 1925 LRA, the landmark case of Williams and Glyn's Bank Limited Boland had upfront altered the position and determined that an interest under a trust for sale would bind a purchaser if the beneficiary were in actual occupation. Transitioning to the second element under Schedule 3, Paragraph 2, it was established that legal possession is not equivalent to the actual occupation. Following the case of Hodgson and Marx, actual occupation is intended to include the mere physical presence of someone other than the vendor. Boland's case ruled that actual occupation is a matter of fact and not a matter of law. Hence, the phrases shall be read as per ordinary words of plain English. Accordingly, what was required was a mere physical presence on the land, and the word actual was not intended to introduce any additional qualifications nor some entitlement in law. King's North Finance Company Limited and Pizat had also illustrated that occupation does not require a continuous and uninterrupted presence in the property. As the saying was introduced in Lloyd's Bank Limited and Rosette, a little occupation will go a long way. In the wake of the recent case of Thompson and Foy in 2009, a collective interpretation of actual occupation was laid down for benefits of future conveyancing in the United Kingdom. First, the word actual occupation should be given its ordinary meaning where physical presence is emphasized. Secondly, it does not necessarily involve the personal presence of the person claiming to occupy. A caretaker or the representative of a company can occupy on behalf of his employer under AB National Building Society and can. However, actual occupation by a licensee who is not a representative occupier does not count as actual occupation by the licensor. Besides, the mere presence of claimant's furniture will not usually be taken into account per Strand Security and Caswell. 1 year later, the case of Link Landing Limited and Bastard had confirmed that the principles in Thompson and Foy, while focusing on the degree of continuity and permanence of occupation. For the third element of Schedule 3, Paragraph 2, which is at the time of disposition, it is now settled that a person cannot claim the benefit of the schedule unless he is in actual occupation of the land at the time when the legal documents are executed and the money is released. Reliance to the case of AB National Building Society and Can, a purchaser will not find the value or the use of his lands diminished by the emergence of an overriding interest in the interval between the sale and the registration as the new legal owner. An actual occupation must exist before the completion of the transaction in order to increase the chances that it will be discovered in time for the purchaser to react accordingly. In conclusion, Schedule 3, Paragraph 2 of Land Registration Act 2002 is indeed a big crack in the mirror, and the purchaser is required to protect himself by making inquiries and reasonably inspecting the property to discover any third-party rights. Such interest in existing behind the trust of land is not found anywhere in the land register, and its purpose to reflect full character of the land is indeed defeated under the English land law.
As mentioned above, the Property Legislation 1935 marked the end of 100 years of reform of land law, where the land can be registered in a simpler, faster, and safer way. Furthermore, it also ensures that the land registration will work more systematically. However, there are some flaws remaining which should be reformed again in order to ensure it evolves and suited the society today. In the era where everything is being computerized, e-conveyancing has been introduced in the system of land registration. Conveyancing in computer terms is communication and registration. In other words, the act of registration is the act of creation of the title. To put the current paper transaction involving the land registry on the computer means that the practitioner will create an electronic deal and send it to the land registry following an approved electronic format. Under the proposed system, a buyer and seller would electronically communicate as well as send or receive any documents like a contract draft. Any amendments will also be incorporated and approved electronically without involved traditional post. This has been expressly stated in the Land Registration Act 2002 with regards to the e-conveyancing provision as an attempt to reshape conveyancing to ensure its compatibility with the commercial world of the 21st century. The system is being introduced on an incremental basis so that it will be more manageable to users. It only deals with matters which are on a basic level, for example, to enable the deeds to be signed electronically and slowly expand to mortgages. Users can apply for adverse possession notifications, upgrade title, and utilize other online services as well. Furthermore, the process of e-conveyancing will be voluntary and therefore no solicitor or licensed conveyancer will be forced to initiate changes to their current practice. The introduction of e-conveyancing was essential to combat the anxiety created by the registration gap. It was described as an inevitable hiatus between the completion of the transaction in the solicitor's office and the actual registration of that transaction. This apprehension is compounded due to the multiple parties that are often involved in a real asset transfer and the numerous ways a transaction can fail. Besides that, the e-conveyancing also aims to correct many problems that plague the English system, such as lack of transparency and uncertainty, as well as general risks and anxieties faced by those involved in any transaction. E-conveyancing will not only make the registration of land faster, safer, and simpler, but also seems to be saving in the cost as well. For instance, conveyance made by electronic means will save £16 in every case as compared to before. Furthermore, all information can be found in a database where it allows the user to easily obtain relevant information from a single source, as opposed to the current practice of contacting numerous different bodies. To conclude an agreement or contract, there must be an authority who signs on it to confirm its legality. Therefore, e-conveyancing works hand in hand with the Electronic Communication Act 2000, which allows the online conveyance to have legal effect. Section 7 of the ECA 2000 had endowed an electronic signature the same legal status as a physical one. Therefore, the requirement for manual signatures of transfer documentation will not be seen as an obstacle anymore. An electronic signature will be treated as a certificate attached to an email, and certificates from electronic signatures are available from bodies known as trusted third parties, such as VeriSign and British Telecom Internet Security Service. With all the benefits laid down in front of e-conveyancing, there are inevitably still much to be done in the United Kingdom to raise it practically. Looking into the prevailing system, a wide array of e-conveyancing technology is in great need to supplement the broad framework provided by the LRA 2002. In particular, the provision for electronic signature and electronic fund transfer (EFT), which will enable automatic and simultaneous transfer of funds, requires further improvement in terms of the network system and database stability. This is crucial when all funding is confirmed as being available for payments between buyer, sellers, lender, and conveyancer. No doubt that computerizing everything will demand a substantial amount of budget, and the government had in fact halted several programs concerning the progression of e-conveyancing due to soaring costs and limited interest.
the government should work together with commercial suppliers as cooperatively they can ensure that the process of implementation of the e-conveyancing system is done smoothly without hitch. Even though e-conveyancing has been implemented in the law, it is a continuing effort to realizing and implementing it so as to achieve a maximum participation rate. It will get rid of the gap between transfer and registration and also encourage a move towards the ideal circumstances that register should be a complete and accurate reflection of the state of the title of the land at any given time accordingly.
As a concluding remark, the purpose of land registration is to bring certainty to land ownership by establishing a register of titles that is conclusive as to ownership and which is backed by a legislative and financial guarantee. As discussed above, registrable interest, registrable estate, and registrable charges are examples of rights which will be reflected and are discoverable upon registration. While this may be true, as we shall see, the mirror principle does not operate fully in the system of registered land in England and Wales. Even under the Land Reforms Act 2002, as there is a list of rights that can take priority of the land automatically without the need of being registered. These rights are well known as overriding interest and it constitutes a track in the mirror. On my perception, overriding interest ought to be retained, yet it cracks the mirror as it will portray the properties of the unfortunate. Though there are still highlights in the cracks of the mirrors due to overriding interest. Thus, it yet be seen whether the reforms were adequate to cope and conceive with a modern society and the development like the e-conveyancing system. Thank you.
Thank you.